We have a debate going on in this committee that started under the Biden administration. I can't recall, having been here a few years, that we had it before. And it's a question of whether or not we should have people who were public defenders serve on our federal bench, either at the appellate level or at the trial level. Some of us believe that we've had some extraordinarily talented young people, men and women, who have backgrounds as prosecutors who have served us well and continue to on the bench. Ms. Freeman, you're a classic example of someone who started off as a prosecutor and went into the magistrate position, comes before us today seeking this circuit court appointment. Judge Davis, Judge Davis as magistrate, I confused that. Ms. Freeman, background as public defender. And I'd like you, if you can, to comment for a moment if you bring any particular bias to the role of circuit court judge based on your previous professional experience. And perhaps you would like to at least refer to the case of Anthony Velasquez, which I think is a good illustration of your background.
Thank you, Chair Durbin. In my 12 and a half years of service as a federal public defender, I have represented indigent individuals regardless of any personal views that I might have about the case matter, because that was my duty to serve the court and to zealously advocate for their interests. I have fulfilled that duty as an advocate, and if confirmed, I would fulfill the very different duty of a judge, which is to fairly and neutrally apply the law to the facts at hand in each case. And thank you, Senator, for referring me to one of the matters that I handled along with a colleague in the Third Circuit Court of Appeals. That is a case to which the court appointed my office to handle at the appellate level after he had been pro se in the district court. It involved a challenge to a state court conviction and an issue about whether certain procedural requirements had been fulfilled. And the Third Circuit agreed that they had not. And because of that, the court ordered that a writ of habeas corpus should issue and that he should be entitled to a new trial. And that was all to protect the fundamental rights that the Constitution guarantees.
And I might add that the Third Circuit included 2 Republican appointees who agreed with your argument and granted the habeas relief sought by your client. They had specific praise for your advocacy. Judge Davis, your background when it comes to prosecution includes a case which had some application at the time and still does, U.S. versus Shaffinia. Would you like to tell the committee a little bit about that experience?
Certainly, and thank you for the question, Chair Durbin. United States versus Shaffinia was a case that was involving a very important issue that still confronts this nation today, and that is the issue of drug diversion involving opioids. In that case, there was a criminal conspiracy that was led by a doctor and a pharmacist, as well as other individuals who were running what in parlance is commonly referred to as a pill mill. I led the investigation of that case. I indicted the case. I prosecuted the case all the way through. 4 of the 5 defendants pleaded guilty. The 5th defendant opted to go to trial, but on the 2nd day of trial, after I think maybe one witness, he also pleaded guilty. And it was one of the first cases in the Eastern District in which we prosecuted a large-scale opioid dealer. Dr. Shaffinia had at that time been one of the highest level of prescriptions for these opioids in Michigan. And because of that, these drugs were not only going on the streets in and around Detroit and Michigan, but they were also going outside of the state.
I would just say, and closing my questioning here, that both of you bring extraordinary experience to this new pursuit in your careers, and I think bring the kind of personal and professional backgrounds which are important that the court see on a regular basis when they deliberate. I thank you both for being here today.